You're on live? You are on live? One second. Good. Good evening to all of you. As promised yesterday, I just gave you an introduction of the specific effect and the contents of the specific effect. In fact, we'll go to the smaller sections first before we come to the bigger section that is specific performance. First and foremost, we'll discuss the ambit of section 6, 7, and 8 of the Specific Relief Act 1963. Here, this is a very small section which says if a person has been dispossessed from the property other than by due process of law and that he is out of possession, he can file a suit in a summary nature or called a summary suit within 6 months from the date of his disposition. Suppose a person is dispossessed other than by due process of law or taking law into your own hands, then the tenant or the person who has been dispossessed can file a suit for possession under section 6 and 7 of the Specific Relief Act. It's a summary procedure that has been followed and it has been disposed of within 6 months. But the question is, within 6 months of the date of disposition, he must file the suit. But what are the essential ingredients he has to prove and establish? First and foremost is he must first prove his possession, and he must prove his position, and whether he's a tenant or an occupant, or in what capacity he was occupying the property, and what are the documents which support his possession, like electricity, water, so on and so forth. Then these documents, if they are filed into the court, summons will be issued to the other side, and the other side appears and files the written statement, and in a summary manner, the suit will be disposed of. The only qualification is the suit has to be filed within a period of 6 months. Are you able to understand this? This is what section 6 and 7 deals with. Then we go to a small section called the suit for rectification. Suit for rectification is that is laid down in section 26 of the Specific Relief Act. It's a very small section which says suppose clerical, arithmetical, or some errors occur in a document, or let us say revenue entries have not been done properly, or your name has been deleted from the revenue records and some other's name has been inserted. Law has provided a summary relief called rectification. Rectification means the word rectification comes from the word rectify. Rectify means correct. Then in that case, you file a suit under section 26. Then you also have to file the parent document, and it is better that you make the Tahsildar or the sub-registrar also a party, because your parent document has to be corrected or has to be rectified. Then in that particular case, under section 26, you can file a suit for rectification and correction of the entries made in a registered document or in the revenue records. But the court fee what you pay for a suit under section 26 is under section 43 of the Court Fees Act, you only pay a court fee of 15 rupees, 1/5 for correction. It's a very, very small, meager amount which is paid towards the court fee. Again, I repeat, rectification means rectifying any wrong entries, deletion of names, or correction in the parent document wherever mistakes and errors have occurred. Then in that case, you can file a suit under section 26 before a civil court and ask the wrong entries to be rectified and corrected. But please remember, when you file a suit for rectification, it is better you file it within a reasonable time. Of course, there is no limitation period fixed for rectification. You can file it at any time. Now, because it's all right, the easiest process is both if the vendor and the vendee draft a document of rectification, it's easy, you can get it registered. But normally when the vendor sells the document, sells the property, he may not have any interest to come later. So that is the reason why this remedy of what is called rectification is provided under the Specific Relief Act. That is section 26. Then we go to section 27 and 28, which deal with what is called rescission of contract. RESCISSION, rescission of contract. Rescission means avoid, retract, revoke. There are three meanings that can be attached to it. Whenever a contract is vitiated by the vitiating elements of contract, a contract is voidable. Then, in that case, when the consent is not free, either party to the document can go back or retract from that document and exercise the right of rescission. The word rescission comes from the word resign, avoid, retract, revoke. There are four meanings that can be attached to it. But here, one important thing you must remember is suppose, let us say, there has been a fraud played by the vendee in misleading the vendor, or the vendor plays a fraud whereby he misleads the vendee. Vendee thinks that he is purchasing some specific property, but some other property is sought to be sold through an agreement of sale. Then he can avoid the contract and say it is hit by the vitiating elements of contract like coercion, misrepresentation, fraud, undue influence, or mistake, unilateral and bilateral. So, but once you want to resign the contract, once you want to avoid the contract, once you want to go back on the contract, then in that case, whatever monies are had and received by the vendor under that voidable contract has to be restored back to the opposite side. There is no question of having the cake and eating it. When you want to have the cake, you must also suffer. The question is the money which you have received from the other side. When you want to avoid a contract for some reason or the other, you have to restore it back to the opposite side. That is why it is said rescission is not allowed unless you are prepared to return back the money what you have received. That's what recession is. Not much of importance can be attached to this. Recession takes place very, very rarely. Suppose, let us say, a time frame is fixed. Let us say within 6 months the transaction has to be completed. Then the vendor does not come forward to fulfill his obligations under the contract by paying the price and getting the document registered. Or suppose there's a clause strictly within 6 months the document, the balance of the sale consideration has to be paid, and if you don't pay it, your rights under the agreement shall stand forfeited. Then, in that particular case, the proper step that which the seller has to do is he must give a notice of revocation and say you have not kept up with the terms and conditions of the contract, so I'm residing from it. I'm avoiding the contract. I'm no more bound to execute and register the sale deed. So here rescission is normally resorted to only as an exception, not as a rule. That's why I said whenever a contract is made under Section 55(2) of the contract, the Transfer of Property Act, time is not the essence of the contract. But for exercising that right or exercising that facility, you must be bound by the terms and conditions of a contract. When you try to violate it as a vendee or as a purchaser, you don't pay within that time, or you do certain act which is inconsistent with the terms of the contract, then in that case, the vendor can avoid the contract, can resign the contract, but on the doctrine of unjust enrichment, whatever is had and received has to be restored back to the opposite side. This is what rescission means, and you have to understand it that way. But not much of cases don't come under that, but very, very rare you find. But still, that is there in the statute book. That is the relief of recession. Recession means avoidance, retraction, revocation, or avoiding it for all and trying to say that I'm not going to be bound by the contract. I'm canceling the contract. Your rights to get the sale deed executed and registered stands forfeited. This mostly arises in the case of sale of goods. In the case of sale of goods, what happens is goods which are transmitted, the time frame also is fixed. Within 3 months, you must make the payment. Delivery is subject to making payment. If you don't make the payment as a buyer, the seller can stop the goods in transit and take it back and avoid the contract and also say that I'm not going to be bound by it. This is what is called rescission of contract. These are all small sections, please. Much of importance need not be attached to it. But the next section, which I'm going to discuss, is a very important section. Sections rather, they are called cancellation of instruments and degrees. See, this word instrument has got different connotations, different meanings from different professions. For example, uh, instruments differ from person to person. Suppose a person is a barber, his instruments are the scissors and the barber's comb, which he uses for hair cutting, or the shaving razor, or the shaving foam, or what is called the brush, which he uses as his instruments in doing the shaving as well as the haircut. As far as an architect is concerned, the set square, protractor, scale, measuring tape, and all these things are important as far as an architect is concerned. As far as an engineer is concerned, he draws a sketch, he uses a marker, then he prepares it according to scale, and then does everything. And those implements which are used for his work is called instrument. If you go to a washerman has got his tools also. That is, his tools is the instruments which he uses in washing your clothes and ironing the clothes, or the ironer which he uses to make your clothes proper. Then, if you go to a doctor, his instruments are the forceps, scissors, and other surgical instruments which are used in performing an operation. That is called an instrument as far as a doctor is concerned. But as far as a legal counsel is concerned, his instruments are the books, the pen, the paper, and the precedents which you use for the purpose of drafting a case, preparing a case, and attending to your client's queries, so on and so forth. They are called instruments. So, but instrument is properly defined as the stipulations or the conditions which are incorporated in a written document is what is called an instrument. For example, Vikraya Patram, that is your sale deed, agreement of sale, then you've got gift deed, then you've got the mortgage deed, then you've got the lease deed, so on and so family settlement deed, partition deed. All these things are called instruments as far as law is concerned. Then I also, when I dealt with the CPC, I said what a decree is. Decree is supposed to be a distillate of the judgment. Summons substance of the judgment is what is called a decree. What is executed in a civil court is only a decree, not the judgment. I think this I've already discussed when I was dealing with civil procedure code. Why I'm trying to tell you all these things is this is a preview of the subject which we are now discussing: cancellation of instruments and decrees. Whenever a contract is voidable, when it is when it is hit by the vitiating elements of contract like coercion, misrepresentation, undue influence, fraud, mistake, unilateral and bilateral, the contract is voidable. Suppose you put a person under fear, under threat, or you try to assault him, and in order to take his signature on a particular document. Has he executed the document in a sound state of mind, sir? No. Why? Because he is scared of his life and puts his signature in those circumstances under closed doors. Then, in that case, he can avoid the contract and file a suit for avoidance of the contract or cancellation of any document which he has executed. That is when it is hit by coercion. When it's hit by misrepresentation, when a person makes a statement without verifying its truth or makes a statement recklessly, then the other person to whom the statement is made acts on the representation, changes his position, which he would not have done but for that representation. It is said the contract is hit by misrepresentation. Then, in that case, you can always file a suit for cancellation. Third one is fraud. It's the most dangerous one. Wherever wherever the person who makes a statement recklessly, knowing fully well the statement made by him is not correct or it's not true, or makes a statement in order to compel the other person to enter into a contract, or practices what is called deception or deceit in order to put the other person to loss, then we say that the contract is hit by fraud. Then we go to undue influence. What do you mean by undue influence, sir? That means once one person is in a dominating position compared to the other, or he is in a fiduciary capacity compared to the other, and the other person has no other option than succumbing to the representations made by the superior person under whom he is working or so, then it is said contract is hit by undue influence. In that, I think I've discussed a case also called Alcard versus Skinner. In that, what happened, perhaps in India, we are all bound by our gurus and the Madhadipatis. As far as the Christians are concerned, they are more orthodox than us. They are completely under the grip of the Mother Superior, who is the head of the church. In this case, what happened was Alcard, who was a Christian, she approached the Mother Superior, that is the defendant, saying that I want to join the church. I want to dedicate my life completely to the church. I want to be a nun. Then the mother superior gave a representation. Sir, if you want to join our church, you must give up all your properties and dedicate the properties to the church. You shall not own any properties. You shall be completely under the control of the church. And in other words, take a sannyas life. Of course, sannyas is not possible in Christians. But anyhow, what she did was, basing on the mother superior's representation, she dedicated all her properties in favor of the mother superior. Then what happened was, I think perhaps most of you have seen the movie Sound of Music. In Sound of Music, the lady joins in the church, and then when she's fed up, she wants the material pleasures. She wants to get out, but the church is not allowing her to go out. But voluntarily she goes out and then gets married and all. That's what Sound of Music picture was. But here, as far as this Alkar was concerned, after 5 years, she got disgusted with the life in the church and she wanted to leave the nunnery. Then, after leaving the church, 3 years after that, she realized that she has dedicated her properties to the Mother Superior, and people like you and me advised her that it is vitiated by undue influence. Why? Because the Mother Superior was in a position of undue influence. She was in a fiduciary capacity compared to you, because she is the Mother Superior and you are the disciple. And on our representation, you dedicated all your properties to the church, and you are completely under the dominance of the Mother Superior. But what happened was, this lady kept quiet for 5 years and brought an action to set aside the dedication made to the church. What the courts in this case said was, though the transaction is hit by undue influence, Mother Superior was in a dominating position or a fiduciary capacity compared to the disciple, but still she took 5 years to reclaim the properties. She had independent, she was capable of having independent legal advice outside, and since she kept quiet for 5 years without bringing a suit for setting aside the dedication, the court negatived her action and said, you cannot get back the property. So once everything is lost, everything is lost. That's all. So you must file a suit immediately or within 3 years from the date when you give up the nunnery and come outside. That's what was held in that, what do you call, undue influence. Then when we come to mistake, there's one case called Blenkan versus Blenkiran and Company. Blenkan was a fraudster. Please remember, whenever you enter into a contract, there must be consensus ad idem. Consensus ad idem. Meeting of minds and meeting of bodies should take place at one and the same time. There must be identity of the person with whom you are contracting, and there must be an identity of the property which you have contracted for. In this particular case, what happened was, Blenkan was a fraudster. He is a noted cheat. Then what happened was, the question is, Blenkiran and that is Blenkiran and Company brought an action against Blenkan because he entered into a contract masquerading himself as saying that he is Blenkiran and Company, and Blenkiran are one and the same. And the person who entered into the contract with them was under a mistake of identity. They didn't know that Blenkan is a separate person and Blenkiran and Company is a different person. A mistake occurred. Then, in that case, the courts held that the contract can be avoided because there is a mistake as to identity. Then we go to mistake as to subject matter. What do you mean by mistake as to subject matter, sir? Suppose A, who is a vendor, has got different properties at different places. The vendee, the purchaser, is interested only to purchase a particular property. Here, what I think is, in my mind, sir, what property is going to sell is the property at Banjara Hills, and which I want to purchase, because Banjara Hills is supposed to be a posh colony. But in the mind of the vendor, he does not want to sell the Banjara Hills property, but he wants to sell the property at Panjaguta. Here, as far as the subject matter is concerned, there is a mistake committed by either side. It's a bilateral mistake. I think in one way, you think in one way. So the identity of the subject matter is not clear. Then in that particular case, the contract can be avoided or signed it, or It can be cancelled also. Here, sometimes if you go to agriculture, as far as immobile properties are concerned, there is no problem. If you go to agricultural lands, suppose you have a survey number 91. Survey number 91 has got subdivisions. 91 by R, 91 by R, 91 by E, 91 by E, then 91 by E, 91 by U, so on and so forth. I am under the impression you are going to sell me the property of 91 by R because it has got three sides road. But as far as the vendor is concerned, he says, I'm not selling that 91 by R. I'm only selling you a 91 by E, where our minds don't work. We don't agree upon the subject matter. You think one way, I think one way. Here is a mistake committed on either side. There's a mistake as to the identity of the subject matter. Then, in that case, the contract can be avoided. In all these scenarios, it is said a suit for cancellation would lie in a civil court under section 31 to 33 of the Specific Relief Act. Suppose, let us say, a promissory note is taken under duress, putting you under fear of threat and injury. Then, in that case, you have not executed the document voluntarily. Then, in that case, you can give a police complaint and also file a suit to resign or to avoid the contract. I file a suit for cancellation of that particular document as null and void. So, the question is, who can file a suit for cancellation? A person who is a person who is a party to the contract, either as the vendor or as the vendee, only those people can file a suit. A third party cannot file a suit. This is a basic thing you must remember, sir. You must be a party to the document. You must be a party to the transaction. You must be a party to the contract. Then alone you can file a suit. If you are not a party to the document, you cannot maintain a suit for cancellation. Again, it is based on two maxims. One who seeks equity must come with clean hands, and one who comes to equity must do equity. What do you mean by that, sir? One who comes to equity must come with clean hands means you shall disclose all the facts, all the necessary ingredients, all the necessary factors which vitiates a contract. For example, if you take the case of fraud, for the simple reason, in the fraud, what all simply by saying it is actuated by fraud, you cannot sustain an action. What you have to say, what are the incidents which constitutes fraud, and how you have been defrauded, how you have been made a victim of deception, how the representation was made, why that representation is false, or the person making that representation knew that it is false, but still induces you to enter into a contract. All these ingredients have to be mentioned. In addition to when was the fraud committed, when did it come to your notice, how did it come to your notice, how you found it out, how you detected it after taking certified copies of the document, so on and so forth. Then all these ingredients will have to be clearly pleaded and clearly established, because under Order 6, Rule 2, Civil Procedure Code, whatever you want to state, you have to state it in writing. If you don't state it, it is deemed that you have given it up. That is why it is said, plead and then prove, not prove and then plead. So those are the ingredients which you have to prove as far as fraud is concerned. The fraudulent acts, the deceptive acts, or the deceitful acts which has been committed by the other side, where you have been defrauded or you have been taken for a ride, they have to be clearly pleaded. Simply by saying fraud will not take you anywhere. But please remember one thing, that as far as all suits concerning fraud is concerned, it is not the date when the fraud is committed, but on the day when you discover the fraud by whichever means you like, that is the period of limitation. So, as far as cancellation suits are concerned, Article 58 and 59 of the Limitation Act says the suit has to be filed within 3 years. But in the case of fraud, when all the ingredients are present, you have pleaded and then established that your fraud has been committed. It is 3 years from the date when the fraud is discovered, or you had the means to discover the fraud, not on the day when the fraud is committed. Are you able to understand, please? And one more important thing you must remember is a party to the document alone can maintain an action for cancellation. A person who is not a party to the document cannot maintain an action as far as cancellation is concerned. This is as far as instruments are concerned, sir. Then we go to cancellation of decrees, because it is also contained in the same sections. Suppose, let us say, a civil suit has been filed and Deliberately, the plaintiff has not shown you as a defendant. Your interests are involved. The property belongs to you. The property is owned by you. The documents are in your favor. But deliberately, though you are a proper and necessary party to the suit, you have not been shown as a party. Then in that case, you can ask for a, so you can file a suit for cancellation saying that fraud has been played, intentionally you have been taken for a ride, intentionally you have been deceived, intentionally the plaintiff has not made you a party, knowing fully well that you are the owner of the property, you are the possessor of the property, all the documents stand in your name, and the suit has been filed against a fictitious person who does not have any rights over the property. Then in that case, you can always file a suit asking the decree to be cancelled. Are you able to understand, please? Proper and necessary parties, what is the provision in CPC, sir? Order 1, Rule 10, bracket 2. At any time when you come to know about it, you can file a suit for cancellation and also say the decree has been obtained by fraud and the fraud was detected by you when the other side came to take possession of the property and the fraud was committed on some day, but you have discovered it on some other day. Then in that case, you can say you have come to know about it or you have knowledge about it, about the fraud only on the date when you come to know about it. That's the reason it is said that this is not the date when the fraud is committed, but it's the day when it has come to your knowledge. Then you get 3 years period to file a suit. And please remember, as far as the provision regarding limitation is concerned, Article 58 and 59 of the Limitation Act says any suit that is filed for cancellation has to be filed within 3 years. Any suit for cancellation has to be filed within 3 years. That is why it is said, sir, the law of limitation bars the right, bars the remedy, but the right still remains. What is the use of having a right without a remedy? You know, wherever there's a right, there is a remedy. But an exception is, but as far as Limitation Act says, you shall not sleep like a rip van winkle for 20 years. Wake up after the 20th year and say that my rights are violated. Court will not come to your rescue. That's why the Limitation Act has been enacted. Article 58 and 59 of the Limitation Act says all suits relating to cancellation has to be filed within a period of 3 years. And in case of fraud, it's 3 years from the discovery of fraud. Then, what is the court fee you pay in respect of a cancellation suit, sir? Under Section 37 of the Court Fees Act, whatever is the value shown in the document, the value of the document, the consideration shown in the document will be the value for the purpose of court fee. As far as the decree is concerned, the valuation will be the amount that has been shown as valuation in the suit filed by the person by fraud. That will be the valuation to be taken into consideration, and the court fee will be paid accordingly. So this is as far as cancellation of instruments and cancellation of decrees are concerned. So then the question arises: suppose a document is cancelled and held to be null and void. What are the consequences which follow, sir? The consequences which follow is that the document cannot be acted upon, the document cannot be relied upon, the document cannot be a source of strength for the person who has obtained such a document, or when you are not made a party, though you are a proper and necessary party, then the decree will not be binding on you. Those are the consequences when an instrument or a decree is set aside. But in all these suits, it is advisable that you make the sub-registrar a party. Why? Because, sir, who is the registering authority, sir? Registering authority is the sub-registrar or the SRO, as you may call it. Make him also a party, because tomorrow and the necessary corrections which have to be made in the records, the authority is a sub-registrar. So once the sub-registrar is known about, has knowledge about it, he cannot reject the cancellation, he cannot reject the decree, but he has to make the necessary corrections in his registers, and a corrected document will be given to you as per the decree. This is as far as cancellation of instruments and decrees are concerned. Then we go to declaratory decrees. First and foremost, you must remember is, as far as these type of declarations are concerned, or this relief is concerned, it is the only relief that is not executable under the provisions of Order 21 Civil Procedure Code concerning executions. It is only a declaration that is given by the court. When does it arise? When a status, position, character, or cadre is claimed by one person. Again, I repeat, when a position, character, cadre, or status is alleged or asserted by one person, and the other person denies your status, denies your position, denies your cadre, or denies your character, then in that case, a suit can be filed for declaration under the provisions of Section 34 and 35. I think most of you have been advocates. You know, the present day litigation which is coming up in courts is when the deceased dies. His widow wants her name to be inserted in the name of her husband in all the records. But the GH or the municipal corporation or the cantonment or the Gram Panchayat or any other authority refuses to do it by saying, please get a succession certificate. They give you a wrong advice, sir. I'm sorry. They should tell you, get a declaration that you are the legal heirs. But please remember there's a discrimination made here. Suppose the deceased died during service. He is a government servant, be it a central government servant or a state government servant. The MRO or the Tahsildar issues what is called a certificate called family member certificate. But you and me who go there, the Tahsildar refuses to give a certificate. Why? Because he says, I'm not the competent authority. The various judgments of our high courts and supreme courts have said revenue authorities cannot grant succession. I think in Muslim they call it as virasat. So the question is, then what the lady has to do, sir? The widow, she has to approach the court, and she must approach the court and say, "Sir, please declare me as the legal, as entitled to the legal status as a widow of so and so." But one important thing you must remember is, such types of suits are very very common now. Because as far as movable property is concerned, or as far as fixed deposits or money is concerned, you file an OP under the provisions of the Indian Succession Act 370 to 372 of the Indian Succession Act for issuance of succession certificate to receive the debts. Then, but you cannot ask for immovable property. Unfortunately, there are some loopholes in our law. When you say succession certificate, you should also include movable property as far as immovable property also is concerned. But our law is silent regarding it. They say regarding movable property or the debts or the monies which you have to receive from various institutions, a OP has to be filed or original petition has to be filed under the provisions of 370 to 372 of the Indian Succession Act claiming succession. And the authority which decides these matters as far as our twin cities or metros are concerned is a senior civil judge. He is a designated authority as far as succession certificate matters are concerned, irrespective of the amount involved. Madam. So it's a very costly affair, sir. Unfortunately, what happens is the disease dies in distress. When he dies in distress, he does not leave any money for his dependents. I think perhaps most of you have been seeing the TV advertisements, especially I think if I remember Policy Bazaar. The widow just waits and says, if my husband had taken a policy, lifetime policy, all my woes would have vanished. I would have had money to pay my debts. I would have had money to educate my children. I would have had money to pay the EMIs. I would have had money to maintain myself. But unfortunately, my husband has left without leaving anything. And the lady has to steal, beg, or borrow in order to make a living. But when you file a petition for succession certificate, please remember government is not lenient towards you. They say, దేవుడు వరం ఇచ్చిన పూజారి అడ్డొచ్చాడంట. Government says, all right, you will get the money. You will draw the money. You will get the money of your husband from fixed deposits or savings banks, etc. But what I should do? I should get my share. That share is in the form of payment of cash court fee. No doubt, The stamp duty court fee which you pay when you file an original petition is 10 rupees only. But along with that, you also have to pay what is called cash court fee that goes to the state government. That cash court fee is according to a percentage you have to pay. Unless you pay the cash court fee, your succession certificate will not be granted. But fortunately, there is a provision under Section 151 CPC inherent powers of the court. Court can postpone payment of court fee till the succession certificate application is decided. But if you want the certificate in your hand, then you have to pay the cash court fee. There is no other go. Unless you pay the cash court fee, your succession certificate will not be granted to you. Your copy will not be granted to you. So these are all the hassles as far as succession certificate is concerned. That apart, as far as immovable property is concerned, it is not covered by the Indian Succession Act. It is covered by the civil law. What you have to do is you must file a suit for declaration of legal status. All the legal heads will have to join together and ask their status to be declared as a widow, sons or daughters of the deceased. Then mostly what happens is no one is to contest your application, no doubt about it. But still you mention it as so and so versus all concerned. But here, our High Court in some of the cases have decided saying that the provision of as far as declaration is concerned is attracted only when the question is you try to what do you call where the question of declaration is available only when you mention a contesting party. In that case, what we people do as advocates is we make the GHMC or the municipal corporation as one of the defendants. We make the what do you call other company or so as one of the defendants to show that you are the legal heads, you are entitled to the legal status, and that the other person, that is the defendant number two or whomsoever it may be, is contesting your claim, is contesting your position, is contesting your status, and is refusing to do certain things which is obliged to do under the law. Then you ask the court to declare that you are the widow and the children of the deceased, and you are entitled to the legal status as such. As far as legal status is concerned, there is no problem at all. Why? Because the court fee what you pay is only 10. Court fee what you pay is only a minimum amount. You value it at 20,000 or 30,000 and pay the court fee. And normally it is filed in the junior court. And then the real problem comes when it comes regarding the property. Unfortunately, one of the judgments of our Telangana High Court says when a declaration is sought regarding immobile property, even if it's a widow or sons who have claimed that status as legal heirs, they have to pay the court fee on half the market value of the property. They have to pay court fee on half the market value of the property. Unless they do it, a suit for declaration is not maintainable. The person who wrote that judgment is a retired judge and now is the now is the inquiry commission for the electricity scam. I think I don't want to name him. He was incidentally my student also. In one of the seminars, I just asked him a question, sir. A lady who should not lose her husband, a lady who should not lose her husband on whom she is depending, the children who do not have the affection of their father, is it proper for you to direct that half the market value has to be paid towards court fee? He says, sir, I know myself that the judgment passed by me is wrong or erroneous, but still no one has challenged it in the Supreme Court. If it was challenged, perhaps it would have been set aside. But that is the irony or the difficulty to which a widow is put today. She should not have lost her husband. She has lost her husband. Her husband's own property, when she wants to succeed, you say, no, pay half the market value. Then in that case, the what is called the government also becomes in Telugu what is called rankamode. The question is, government also wants its revenue. It's unfortunate. Then the question is, once a suit for declaration is filed, they claim to be they are entitled to the legal status to succeed in the property of the deceased. Then in that case, half the market value has to be paid towards court fee, and then alone your suit will be numbered. Then we come across the cases under the family law. After the Family Courts Act came into force, all matters relating to family, whether it is marriage, whether it is money, whether it is payment of terminal benefits, or whether it's regarding deciding as to who the legally wedded wife is, who is entitled to the benefits, all those things, are the Guardian and Wards Act also. Only the family courts can decide, civil courts cannot decide it. Then what happens is our Supreme Court has gone on record saying that, contrary to the Hindu law, saying that a person can marry two wives, though he is a Hindu, and both the wives are equally entitled to the property. And they have gone to the extreme extent of saying even illegitimate children are also entitled to rights in the property. Or they have even gone to the extreme extent of saying that even a Dasi Putra, that is a child born to a Dasi or a concubine, is also entitled to a right in the property. All these things are there, sir. But once the husband dies, the real Savitigola starts. What happens is, suppose he has died in service, then the question arises, in some of most of the institutions, they offer a job on compassionate grounds. Then on compassionate grounds, let us say the second wife is offered the job. As far as terminal benefits are concerned, the second wife was not in the picture at the time when the nomination was made. Nomination is made in the name of the first wife. Then the question arises, who is the legally wedded wife? The first wife says, I am the legally wedded wife. The second wife says, I am the legally wedded wife. The second wife says, my husband divorced the first wife long back. They obtained a divorce also by customary mode or whatever mode is concerned. Then in that case, the first wife files a case before the family court for a declaration that she is the lawfully wedded wife of the deceased. Please remember, every lady calls herself as the lawfully wedded wife, but no one calls themselves as the lawfully wedded husband. I don't know why. The question is, no one says దాని మూడు నేనే అని చెప్పి ఎవరు చెప్పడు. కానీ భార్య అయితే అంటే నేనే ఆయన భార్య అని చెప్పి చెప్తుంది. అది ఎందుకో తెలియదు, because ours is a male dominated society. Here the question is, there is a what is the question that has to be decided by the court, sir? Who is the legally wedded wife? Who is entitled to the terminal benefits? Who is entitled to the benefits of the disease? And whether the second marriage is valid or not, or whether it's a marriage at all in the eye of law. These are all the points which have to be decided or settled by a family court. Then a declaration is sought for, and the court gives a verdict as to who the legally wedded wife is. But in the meanwhile, what happens is they come to a settlement. నీకు జాబ్ అయితే ఇచ్చేసాడు కదమ్మా, వదిలేసి టర్మినల్ బెనిఫిట్ మనం సగం సగం తీసుకుంటాం. That's why it is said, if both of them agree and settle the matter, there is no problem at all. But then the next question arises. In one of the cases which arose in the civil court was a dispute between the mother-in-law and the daughter-in-law. And unfortunately, what happened was the deceased died when he was an employee of the State Bank of India. And after his death, the bank gave the job to the daughter-in-law on compassionate grounds. It so happened that the daughter-in-law got remarried after the death of her husband, and all the terminal benefits were paid to the widow. Then the mother brought an action, filed a civil suit, saying that under the law of succession, mother also is a legal heir. She comes under class 1 heir under Hindu law. Then earlier, the nomination was in the name of the mother before the marriage of the deceased. But after marriage, what happened was, it so remained. But after marriage, what happened was, the entire benefits was paid to the widow of the deceased. Then the question that arose is, the provident fund and gratuity of the deceased, who should be paid? Whether it should be paid to the nominee or the word family as defined under the provident funds rules and the gratuity rules of the State Bank of India. It so happened that I appeared for the bank and I did not have the rules book with me. I called for the rules book from Kolkata, and in that it is said, a person acquires anything and everything when he is born, but he acquires a family and children after his marriage. So even if the nomination is in the name of the mother does not come within the definition of the word family. The terminal benefits are liable to be paid only to the widow of the deceased. Though she is a class 1 heir specified in the section 8 of the Hindu Succession Act, the nomination which is given to her before marriage gets vanished once a person acquires a family. So that's how the word family is defined under the Provident Fund rules of State Bank of India. The matter went up to the High Court also. Ultimately, mother lost the litigation. Sometimes I literally feel that I've done injustice. Why? Because after all, I've deprived the mother of her share. But still, when I appear for an institution, I have to defend the institution, whether right or wrong, but within the four walls of law. Here, the question is what I'm trying to tell you is when the position is challenged, when the cadre is challenged, when the status is challenged, or when the character is challenged, the only relief open to you is to ask for a declaration. Now I think this is the Ashada month as far as Telugu people are concerned. In Telangana, the Bonalu festival has already started in right earnest yesterday. And Bonalu festival is celebrated throughout the month of Ashadam. After Shravanam it ends. Before Shravanam it ends. But there are people who perform Bonalu even after Shravanam also. What I'm trying to tell you is there's a customary usage of having what is called the Katams and offering bonums to the goddess. Then let us say we have to pass in villages as well. Of course, here we have got regular temples and all. In villages and all, a particular idol of the goddess is in a field belonging to you. People are using that particular pathway to reach the goddess and then offer their bonums and offer their prasadams to that goddess. Suppose, let us say, one fine day you fence up the entire land and prevent me from entering that particular land and praying at the goddess. Then, in that case, the entire village is using it. Entire village is using that particular right from 20 years. Then you cannot interfere with my easementary rights which I've earned, and I can seek a declaration from the court that the other person cannot interfere with my rights as far as offering bonum during the Bonalu festival. Like that, we have got the Ganesh immersion. See, please remember Vinayaka Chauthi. I still remember. I'm born. I've been educated. I'm staying in Hyderabad. Previously, Vinayaka Chauthi did not have that importance. But when Raja Ram Mohan Roy came, he tried to say that he had to spread Hinduism and said perform the puja of Ganesh Maharaj, who is the first prime deity before doing any function. Then, in that case, Vinayak Chauthi started being celebrated mostly in Karnataka, Maharashtra, and northern places. But we today find in Hyderabad, it is done much more than what is done in Maharashtra and other places. Why? Because that is a religious fervor which is what is called, which is generated in the public. And normally we have a big function during immersion day, Nimanjanam as they call it. Tank bund and other river bodies are used for immersing the idols in water. And of course, the government was trying to toy with the idea by saying we want to save the tank bund, and we wanted to save the water bodies. The immersion, naturally, the plaster of Paris which is used is dangerous, and the water gets polluted. And for some time they tried, but the Vinayaka celebrations and Bhagyanagar Samiti protested at it and said, we have been using it from times immemorial, we cannot stop it. Even the High Court went to the extent of saying that immersing idols in the water bodies should not be done. Please remember, it's more in breach rather than being followed. Then, in that particular case, you can take a declaration that you are entitled for that Nimanjanam ceremony, or to have what is called the Vinayaka Chauthi, what is called Ganesh celebrations for 10 days or 11 days. The police gives you the pass to conduct it in pandals. Of course, unfortunately, what happens is these 11 days is misused for all dirty things. That is, disco is played before the god, disco dances also take place, and dirty music also is played. Please remember that is not the idea of Ganesh Chauthi. But please remember, we are all Hindus, pious Hindus, religious Hindus. We follow Hindu customs. Then now the Ram Mandir which has come. Of course, Ram Mandir which has come. No doubt, Ram was a great Lord, I definitely admit. But still, so much of hype need not be given to that. Why? Because they say Ram is omnipotent, Ram is the only God, as if Ram only belongs to you and belongs to only one political party and not to other parties and not to the people in general. Then, in that case, these are all things which are very, very common. Now, after this, you got the Batkama Pandaga. Batkama Pandaga is also celebrated in Telangana by the lady folks. they try to immerse the flowers in river bodies and all. This has been happening from a very long time. But suppose, let us say, someone stops you from doing it, you can take a decree from a court for declaration that you are entitled for that particular right. And in Telangana, especially, there is a scarcity of water. We don't have those river bodies which are there in Andhra. Here, suppose, let us say, one what is called well is only in your field, and it supplies water to the entire fields in the neighborhood. And then, let us say, and you pay the charges, necessary charges are paid. All of a sudden, you stop the water from irrigating the other fields. Then, in that case, a suit can be filed for declaration that you are entitled to use the water from that well, provided you pay the electricity charges, so on and so forth. Sometimes what happens is, especially you see the fields, especially they are normally in a cluster. To reach my field, I have to pass through your field also. Right of ingress and egress is there. You have only one ingress and egress. Suppose you stop that by fencing it, then in that case it causes hindrance. When the entire public is using it, you cannot stop it. A suit can be filed for declaration that you are entitled for that particular right. Then let us say, normally when wherever there's underground drainage, there's no problem at all. But where you don't have underground drainage, there is one thing called SERI, SERI. In conservancy language, it is said the 5 feet lane which is between the two houses to let out rainwater or to let out drainage water is what is called a SERI. Neither party, neither you nor the other side, can construct on that seri, encroaching on that seri. Then the question is, suppose you do it, I can always file a suit for declaration. You are not entitled to do it. I can also ask for injunction to say that you have to remove that construction because it causes hindrance. Suppose you want to say, let us take another alternative, sir. Adverse possession. Adverse akrama, what is called akrama kabza, or what is called naja is fight. Naja is kabza. That means, let us say, for 12 long years, you are occupying a particular land without paying any rent, without any interruption, continuously, and without any objections from the other side. You perfect your title by possession. That's why in law it is said possession is 9 points of title, that only one negative point is when the real owner comes, you have to give way to him. That's why they say in agricultural language, Dunne Varde Bhumi. That whoever is cultivating the land alone belongs to them. That is the reason why the Maifuz Kauldar or Rakshana Kauldar system had come into play in 1954-55. Whoever was in possession of the property at that time was given a certificate called PT certificate or Rakshana Kauldar certificate, and is entitled for 60% of the holdings as far as the land is concerned. And that's why they followed what is called Dunne Varde Bhumi. The land belongs to the tiller of the soil. This is permitting itself in every sphere of activity, sir. Today, if you see, in when the Telangana agitation was in its peak in 1969, they evolved the Mulki rule, where they said you must have at least 15 years of residence in Telangana in order to be entitled for jobs, in order to be entitled for appointments, or in order to be entitled to get an admission in an educational institution and all. The domicile certificate was insisted upon. Even now that is being done, sir. We don't allow outsiders here. We say first preference has to be given to the insiders, then alone it has to go to the outside. Please remember, all these exigencies are coming. But if you are able to show that for 12 years this is being followed, the government or your neighbor cannot discontinue that practice, then a suit for declaration would lie. Then another situation when a suit for declaration would lie is, suppose you file a suit simpliciter for perpetual injunction. You obtain an injunction not to restraining the opposite side not to construct on that property. But in spite of obtaining injunction, the other side goes ahead by making the construction. Are you helpless? You can always amend your plaint and ask for what is called mandatory injunction, and also for declaration to remove the structures which has been constructed during the period when the injunction is in vogue. That's where declaration suits also come into play. And normal declaration suits nowadays, a clash when the head of the Madhadipati or the Jia expires, he nominates his successor. Then normally there's a dispute. Please remember, all of us are human. The other person says, I'm senior as far as that person is concerned. I should have been nominated as the head. Then there is a dispute. The matters go up to the Supreme Court and all. One more thing I should say, this matter arose among our Vaishnavites also. What happened in Tirupati, if you see, the god Venkateshwara normally has the Namam. There are two sects in Vaishnavites. One is called Vadagale, that is where they have that U, and Tengale, that is where they have their Y. Then the question is whether the god has to be decorated with that Y or U, and whether the elephant has to be decorated with U or Y. Matters went up to the Supreme Court. Ultimately, they settled the matter by saying, let us settle it amicably, and the matter was settled. Please remember, this declaration comes into play every sphere of activity, and that's why it is said a suit under 34 and 35 can be filed for declaration, provided you show everything. And then, but one thing is this: though you get a decree, it is not executable, and the provisions of Order 21 does not apply as far as declaration is concerned, and it's a judgment in rem. I think with this we shall stop, and tomorrow when we will discuss the most important chapter called the injunctions as laid down in this specifically fact. Thank you very much. The period for start, the time starts for interaction. Yes. Yes. Any questions, please? Mr. Leela Krishna. Venkat. N. Venkat, sir.
Sir, this is Venkatesh here, sir.
Yes, sir. Please go ahead.
Sir, you told that for declaration, when you ask for declaration.
Sir.
And again, if the perpetual injection granted, if it is not obeyed,
Yes.
then we need to go for mandatory injection. Right,
Sir,
sir?
this is that not yes, sir, not for that, sir. Suppose during the pendency of a temporary injunction, let us say we are not on perpetual injunction as of now. Suppose even in spite of an injunction being communicated, temporary injunction being communicated, the wrongful acts still continue. Then in that case, you can amend your plaint and ask for declaration that you are entitled for this and this has been flouted or this has been violated by the other side, and you can also ask for mandatory injunction to remove the offending structures, please. Yes? Is
Yes,
it clear to Mr. Venkatesh?
Yeah, it's clear.
Next, please. Mr. Suti Kirtan. Any more questions, please? Any more questions?
Please raise your hand if you have any.
ఎవరండి? Mr. Avinash, what is your question, sir?
Raise your hand.
Please raise your hand and ask the question, please. Mr. Avinash.
Sir,
Yes.
good evening, sir.
Good evening.
Sir, in case of declaration of legal status,
Yes.
that is a widow and children to the widow.
Yes.
Sir, is the wedded daughter who is already married to
Right.
somebody,
Right.
and she is married to somebody and living in their in-laws house.
Yes.
Is she also been declared in the legal status as per the new amendment of daughters right in the...
So as far as 29A is concerned, she is also a legal heir, irrespective of our marriage.
Yes, sir. And whom should be made as a defendant in the status of legal heir?
In the case of legal heir, better to make the institution. Suppose the GHMC represented
Yes,
by
sir.
the commissioner, or the Gram Panchayat represented by the commissioner or chairman, whatever the position may be, or the cantonment board represented by the executive officer, so on and so forth.
If suppose if the clients want a legal status, they have nothing.
They will have
Just
nothing.
for-
They are not going to contest, but you have to deliberately make an allegation You have approached them, they negated it, and asked you to take a declaration from a civil court.
Yes,
If you don't do it, 34 and 35 will not be attracted. Why when 34 and 35 is attracted is when a status, cadre, position, or character is claimed, denied by the other side, or sought to be denied by the other side, then in that case a suit for declaration would lie. Here you will have to make out an allegation, sir. After the death of my husband, I approached the authorities. They said they cannot mutate my name in the records unless I obtain a legal unless I obtain succession. They use the word succession. Unless I obtain a declaration. That's the reason why there's cause of action against that institution. You have to create it.
Yes.
You have to create it. Yes, sir.
Yes, sir.
Are you satisfied, sir?
Yes, sir. Yes.
Next, please.
Sir, one more
Yes, go ahead.
personal question.
Yes.
Please don't mind me, sir. Your full name, sir.
My full name is K.Santhanam, Iyengar.
Thank you, sir. Thank you, sir.
Right.
Sir, good evening, sir.
Good evening. Please.
టెనెంట్స్ అడ్వాన్స్ పొజిషన్ లోకి రావాలంటే ఎన్ని ఇయర్స్
12 సంవత్సరాలు.
12 years.
12 years.
Okay. For easement rights, any time they can ask
Easement
for
rights also same 20 years. Easement rights.
20 years.
Yeah, that is by prescription.
Okay. Good evening, sir.
Good evening. Yes, madam.
Sir, in legal declaration suit, sir, is a court fee refundable, sir?
Madam, court fee, unless you go under section 89, the 89 asking for settlement through Lok Adalat or a third party mediation or by any other mode or by alternate dispute resolutions, then alone court fee is refundable, not otherwise. That's what 89 has been provided under the new act. Yes.
Yes, sir. Thank you, sir.
Welcome.
Sir, good evening, sir. This is Anuradha.
Yes, madam.
Sir, in the suit for declaration of legal heir,
Yeah.
apart from the immobile property,
Yeah.
there is a savings bank account and a bank locker. So,
Yes.
how will they consider?
So, as far as savings bank and bank locker is concerned, you have to go under the Succession Act. That is section 370 to 372 Indian Succession Act. But as far as declaration of legal debts is concerned, you cannot join all of them. Only regarding your status you can claim, but not regarding the movable properties or the debts what the disease has left behind. Yeah. Next.
Hello, namaste, sir.
Namaste.
So, na peru Tirupati.
Yes, sir. Mr. Your good name?
Sir, Tirupati, Gowda Tirupati, sir.
Yes, sir. Yes, sir. Go ahead.
Sir, కోర్టు స్టేజ్ అంటే కేసు స్టేజ్ వచ్చేసి మార్కింగ్ ఆఫ్ డాక్యుమెంట్స్
Right.
పోయిన స్టేజ్ లో మార్కింగ్ ఆఫ్ డాక్యుమెంట్స్ అండ్ పిటిషన్ PW 123 అని ఉండే సార్.
Yes.
ఆ కేసు ఈ రోజు మార్కింగ్ ఆఫ్ డాక్యుమెంట్స్ అని లేకుండా ఓన్లీ పిటిషనర్ PW 123 అని ఉంది. అంటే ఏంటి సార్ దీని అర్థం నాకు తెలియదు.
మార్కింగ్ ఆఫ్ డాక్యుమెంట్స్ మీరు ఎవిడెన్స్ అఫిడవిట్ ఫైల్ చేస్తారు కదండి. ఎవిడెన్స్ అఫిడవిట్ ఫైల్ చేసేటప్పుడు యూ మెన్షన్ ద డాక్యుమెంట్స్. The documents should be marked by the court. If your client is not present or the witness is not present, it's posted to another date on which you must get the documents marked through court.
Sir.
Only the court can mark the documents.
Sir, ఈ రోజు స్టేజ్ లో మార్కింగ్ ఆఫ్ డాక్యుమెంట్స్ లేకుండా ఓన్లీ PW 123 అనే ఉంది. అంటే PW 123 అంటే క్రాస్ ఎగ్జామ్ ఉంది సార్. PW 123 క్రాస్ ఎగ్జామినేషన్ అని ఉంది. అంటే వాళ్ళని క్రాస్ ఎగ్జామ్ చేస్తారా?
లేదండి, మీ డాక్యుమెంట్స్ మార్క్ కాకుంటే క్రాస్ ఎగ్జామినేషన్ రాదండి.
అంటే అయింది అన్నట్టు సార్. క్రాస్ ఎగ్జామ్
వచ్చిందంటే కూడా జడ్జికి రిమైండ్ చేయాలి, మీరు డాక్యుమెంట్స్ మార్క్ చేయలేదు, ఫస్ట్ డాక్యుమెంట్స్ మార్క్ చేయమని చెప్పి గుర్తు చేయాలి.
సార్,
unless you remind the court, the documents will not be considered, sir.
Okay, sir.
Yeah.
Thank you, sir.
ఏ కోర్టు?
కరీంనగర్ సార్.
ఎక్కడ? ఏడీజేనా
సార్?
ఏ కోర్టు? Karimnagarla.
Special DMHC excise court lo sir.
Don't take your chances. Remind the judge that she should mark the documents before posting it for cross-examination.
Sir,
మీరు ఒకసారి ఆర్డర్ 18 రూల్ 4 and 5 చూడండి.
order 80,
రూల్ 4 and 5.
4 and 5.
అవునండి.
Okay, thank you sir.
వెల్కమ్. Any more questions, please?
Sir, good evening.
Good evening. Please give out your name.
Sir, my name is Nokia.
Nokia, that is Jamuna. Yes, madam.
Sir, may you repeat once again section 372?
Section?
372.
Section 372 to 370. It's not 372, it's 370 to 374, which deals with succession certificates in respect of the monies left behind by the deceased. And that is recovery of debts by the successors in interest. And there, OP has to be filed on what is called original OP, original petition under 370 to 372 of the Indian Succession Act. And in that, you must mention what are the amounts outstanding, who are the persons to pay that amount, and then also give the aggregate of it, and then pay what is called only 10 rupees court fee you pay at the time of filing. But ultimately, when the succession certificate is granted to you, you will have to pay 2%, 3%, 4%, maximum is 6% of the net amount what you are claiming, sir. Claiming, madam. And it is normally filed in the subcourt, that is in the senior court alone. That is a principal senior civil judge.
Thank you so much, sir.
Welcome.
So one more doubt in the same question.
Yes, madam.
Suppose we do not know how much of or what is kept in the locker.
What?
What
Then
is kept
you can file an application to appoint a commissioner to open the locker in the presence of the bank officials and yourself, and then give a valuation regarding the articles which are found in the locker, and then ask the court to value that, and then pay the court fee, and then say that you are entitled for it by whatever position you occupy. You can file an application. You can file an application to appoint a commissioner to open the locker in the presence of the bank officials and yourself, and then make a panchanama and also the value of the articles that are kept in the locker, and then submit a report.
But the bank people are searching for a legal heir certificate or a successor certificate.
Then in that particular case, you only say that your legal status, you are the legal heirs of so and so.
Yes, I'm one of the legal heirs, but there are other legal heirs.
If they are not cooperating with you, make them as respondents and say that they have community of interest, but they have not joined you, but they are also, and legal heirship certificate should be granted in favor of all of you.
Okay.
Yeah.
Thank you, sir.
Welcome. Next.
Sir, may I ask a doubt, sir?
Yes, madam.
నాకు తెలిసిన వాళ్ళు ఉన్నారు ఒకళ్ళు. సో సొసైటీ sold a land to two persons, sir.
Right.
The second person is known to me.
Yes.
And they have filed a case at Rajendra Nagar court.
Yeah.
And they lost the case.
Yeah.
They have filed case against the first person.
Yeah.
To whom they have the society has sold the
Right.
land.
Right.
And they lost the case.
Yes.
Now if they want to appeal, to which court they have to appeal?
What is the value of the suit?
It is 500 square yards.
No,
sir,
maybe the
somewhere.
value in terms of money for court fee.
Yeah, nearly 1 crore, maybe.
1 crore. Then you have to go to the district court.
District. Why not consumer court, sir? It is society. It is relating to society's.
Maybe,
act.
but the Society's Act, you'll have to see whether you are a consumer and the other person is a provider of services. Then only you can go to the consumer court. You read section 2O of the Consumer Act.
So I have to file appeal
In the district court.
in district court.
Yeah. What is the value? You said 1 crore.
1 crore.
1 crore.
Okay, why not the high court, sir?
Above 1 crore is the commercial court.
Commercial court.
Above 1 crore. I
Okay.
think Rangareddy has got a commercial court. Hyderabad has got a commercial court, but Secunderabad does not have a commercial court.
Okay.
If it's
Okay,
above
sir.
1 crore, it's above 1 crore.
They cannot file in high court, na, sir?
No, High Court has no original jurisdiction. Madam.
Okay, but appellate
The
jurisdiction.
question is, you are saying 1 crore, isn't it, madam? Decree has already been passed or dismissed. Then if it's above 35 lakhs in value, first appeal can be filed in the High Court under the provisions of Section 96, read with Order 41, Rule 1.
Okay.
Yeah.
Okay, sir. Thank you.
Sir, legal heir and succession, can you just?
Sir, as far as legal succession is concerned, sir, it is only regarding receiving of debts, that is the savings bank account, then fixed deposits, or the money or the shares which are matured, that amount, dividends, so on and so forth, they are matter of succession. But as far as legal heir is concerned, it only determines the status of a person, whether he is a son, whether he is the widow, whether he is the daughter, so on and so forth. You don't call the word legal heir. If you say legal heir, they will not grant you. You will only say legal status.
Legal heirs, they won't grant.
You should not mention the word legal heir. You will only have to say legal status.
Okay. Who will give the certificate, sir?
Usually it is the junior civil court, sir. Yeah.
For immovable properties?
Immovable property, depending on the valuation which you give, half the market value which you give, that will be the jurisdiction. Yes, that will be a suit. But here the succession will be only OS.
OS, okay.
Succession is OP, and as far as suit is concerned, is OS. That is as far as immovable property is concerned.
Okay. Sir, are you able to hear me?
Yes.
Sir, this is Yashoda Ande.
Yes, ma'am.
So my question is it like initial ga మనం కోర్ట్ కి పే చేసే ఫీస్ కడతాం కదండి ఇంత ప్రాపర్టీకి ఇంత చేయాలని చెప్పి జస్ట్ ఇన్ కేస్ ఎవరైనా జనరల్ లీగల్ హెయిర్ సర్టిఫికేట్ కావాలి అంటే తర్వాత మళ్ళీ వాళ్ళ ప్రాపర్టీకి ఎలా చేసుకోగలుగుతారండి వాళ్ళు?
అంటే డిక్లరేషన్ తీసుకుంటే సపోజ్ యు ఆర్ డిక్లేర్డ్ యాస్ ఎ లీగల్ యు ఎంటైటిల్డ్ ఫర్ ఎ పర్టిక్యులర్ లీగల్ స్టేటస్, a certificate, a certified copy will be given to declaring you as the widow or children or whatever it is, if it is regarding immovable property. But as far as immovable property is concerned, the court will declare that you are the sons and widow and you are entitled to that property. Am I making myself clear to you, please?
Understood, totally understood. దెన్ వాళ్ళు మళ్ళీ మ్యూటేషన్ అప్పుడు
ఈ డిగ్రీ మీద మీరు మ్యూటేషన్ అప్లై చేసుకోవచ్చు. చేయకపోతే రిట్ వేసుకొని టు కంపెల్ దెమ్ టు రిజిస్టర్ ది డాక్యుమెంట్.
ఓకే, మరి వై ఇస్ ఇట్ లైక్ ఇనిషియల్ గా ఒక ప్రాపర్టీ మీద ఎక్స్ట్రా చార్జెస్ ఇవన్నీ ఎందుకంటారు?
ఐ టోల్డ్ యు మేడం, బికాజ్ ఐ సెడ్ దేవుడు వరం ఇచ్చిన పూజారి అడ్డు వచ్చాడంట, అది కథ.
yes sir,
that's the unfortunate situation.
Okay, fine sir, thank you.
Welcome.
Sir, the family certificate will come where, sir?
Family certificates are normally given for government servants, sir. That is central government or state government. But as far as we are concerned, family certificates should not be. It was previously given, but it is discontinued now.
Yeah, okay. So now your government servants also not getting?
No, government servants will get it, but you and I will not get it if you are not government servants.
Yes. So for them, otherwise only legal head.
That is, you have to go only by that, by a civil suit. And one of the judgments of Justice
civil suit or legal head also only.
Yes, sir. Justice VVS Law's judgment is there. As far as succession or declaration is concerned, only the civil courts can grant. Revenue authorities cannot grant.
Oh, revenue authorities cannot grant.
That's what Justice VVS Law's judgment is there.
Yes, sir. Yeah, of course, succession anyhow court only.
Sub-court, senior court.
Yes, sir.
Sir, I'm sorry once again. I have one more doubt, Andy. Say, suppose one of the petitioner doesn't reside here.
No.
So obviously GPA eskuntam kadandi.
Avunandi.
So GPA eskuntam. So any stage they are not required. A stage lo GPA.
So GPA, suppose he is not able to come, he is not available. He can execute a GPA, and GPA will represent him for all practical purposes. If the court still requires him to come, then he has to come.
He has to come.
If the court requires.
If the court requires. Yeah. Okay. And that can be furnished in the court at any stage of the trial?
No, not at all. The only thing is when you file it through a GPA, then you must file a petition under Rule 32 and 33 for permission to file through GPA.
Okay. Fine.
Sir, that man has to come personally, no sir, no virtual thing.
For what, sir?
Suppose that GPA executed, who has executed.
So he can take his advocate can take permission from the court to speak on virtual mode.
Yeah, if the judge agrees, it is okay.
Judge will definitely agree. High court itself they are permitting. Why not lower courts?
Yes.
Because
so he can, sir.
He can go on virtual.
Yes.
He can go on virtual.
Suppose he stays in US or some other place.
Whichever place his number, he can be on. Because the difference is the timings are different, sir. Our court timings are different, yes. And their timings are different. Or you can ask for video conferencing at a convenient time.
Video conferencing of the court hours.
Yes, sir. Exactly. So corresponding to the time in USA.
Yes, whatever the time in the USA, but here it's daytime or before.
You must request the court, sir.
Yes, sir. Yes. But normally they will accept it.
100% they'll accept, sir.
Hybrid mode, everything is done.
High court itself, we submit our arguments on the virtual mode.
Yes, sir.
But you have more audience when you go personally and argue than talking on virtual mode, sir. God only knows what he's following, what he's noting, and what you are arguing.
Yes, yes. So virtual mode may not help, sir.
See, the question is if you are lazy enough, you don't want to go to the High Court, then you speak.
Yes.
And there's a particular judge who made a remark also when I was arguing a matter, and the other side was my student in the law college. And he said, your professor has come offline and you have come online. Are you not ashamed? Such caustic remark was made.
Drastic. Yes,
normally they discourage virtual, sir.
Yes, sir. Yes, sir.
Any more questions? Yeah. Any more questions?
Sir, family certificate when it requires, and succession certificate when it requires.
It is succession certificate is required for payment of debts by your various institutions. But as far as your legal headship or legal status is concerned, it's required for getting your name mutated, getting all the benefits after the death of the deceased.
Yeah? Okay, sir. Very clearly you told.
Thank you. Any more questions, please?